The defendants numbers 1 to 4 have filed their separate counter affidavits to injunction application and denied the assertions made by the plaintiff in the application and its supporting affidavit full stop. It has been stated that the plaintiff suit is based on malafide and based on falsehood as the defendant number 1 in pursuance of rules and regulations issued the NOC clearance certificate to the defendant number 2 to appoint defendant number 3 as an advertising agent, and as such the injunction application merits dismissal as the plaintiff is seeking to achieve indirectly what he cannot seek directly, to compel the defendant number 2 to continue placing advertisements through the plaintiff full stop. It has been denied that plaintiff and defendant number 2 entered into a formal agreement and the relationship was governed through an informal mechanism full stop. It has been submitted that the alleged financial charge of 22% on invoices due beyond 30 days was never mentioned in either the estimate and budget summary provided by the plaintiff or in the corresponding service order full stop. It has also been submitted that plaintiff has annexed a purported agreement as annexure with the suit, which contains and forged signature of Hamid Farooq, who was the then CEO of defendant number 2 full stop. This purported agreement between the plaintiff and defendant number 2 was itself provided to the defendants numbers 1 and 4 by the plaintiff full stop. It has been submitted that defendant number 1 approached Hamid Farooq directly, who categorically denied ever having signed or executed the purported agreement, and after investigation the defendant number 1 concluded that the purported agreement was false and therefore the plaintiff was not entitled to recover the alleged financial charge from defendant number 2 full stop. It has been further submitted that the plaintiff has never in its regular reconciliations and statements of accounts which it sent to defendant number 2 periodically, ever claimed or raised the issue of financial charges on invoices that were paid beyond 30 days from their date, and the plaintiff has failed to mention the same due and outstanding in its audited financial statement full stop. It has been submitted that the plaintiff has created this issue with a malified intention simply so as to blackmail defendant number 2 and prevent it from shifting to another advertising agency full stop. It has further been was in January, 2008 when defendant number 2 had first intimated to the plaintiff that it wished to appoint another advertising agency in place of the plaintiff and asked for a provisional NOC, and when defendant number 2 agreed to continue the relationship, this claim was dropped by the plaintiff and this issue was never raised until 2011, although the parties regularly reconciled their outstanding amount full stop. It has also been stated that the plaintiff has approached this court with unclean hands and is not entitled to any relief, whether equitable or otherwise, full stop. It has further been stated that the plaintiff has failed to make out a prima facie case, nor the balance of convenience lies in its favor, full stop. It is submitted that it is a settled law that no injunctions are granted in a suit for the recovery of money, as there is an effective alternate remedy available and a plaintiff cannot suffer irreparable loss, full stop. Therefore, the application under reply is liable to be dismissed with compensatory cost, full stop.